The third case on this morning's docket, case number 116333, in the matter of the estate of Roy B. O'Rourke.
May it please the court, my name is Arthur Palmer. I represent the petitioner in this case, Ms. Donna Fairbanks, along with my co-counsel, Mr. Bruce Hanson. The case is a lot more simple than everything else you've heard this morning, I think. The case involves simple facts and basically one rule of law, so maybe we can shorten this a little bit. I would, with your court's permission, like to reserve 2 minutes for rebuttal, if I may.
2 minutes is granted.
Thank you, Your Honor. This is an action from which the appeal below was from the court's order admitting a will to probate, even though the will was not offered within the 6 months limitation. The facts of the case are, I think, simple. Mr. O'Rourke wrote his will in 1954 and a codicil in 1958. Under the statute then in effect, at the suggestion of his attorney, he deposited the will with the probate court, where it is supposedly kept in a locked box along with a ledger. And at that time, under the statute, the clerk was required, I guess, to watch the obituaries, and if the clerk learned that someone had passed away, it was the clerk's obligation to try to advise someone. That system was somewhat disrupted in 1976 when the courts were consolidated and the probate court was merged into a part of the district court.
But when they had that, when the courts no longer accepted wills for deposit,
yes.
Nevertheless, the clerk was still required for the next, I think, 75 years
Yes.
to maintain the ledger, as you mentioned, or the list of wills. So it was still, to this day, incumbent upon the clerks to maintain that list of deposited wills, was it not?
It supposedly is, Your Honor. Yes, that is correct. The court's rule is very clear that the clerks are obligated to call the wills every year, but to retain them for a period of 75 years. So I guess by the end of 75 years from 1976, that mission will be completed. The decedent, Mr. O'Rourke, died October 15 in 2014. Within a few days thereafter, the two executors named in the will and the two beneficiaries under the will first checked Mr. O'Rourke's bank balance and didn't find the will, and then proceeded promptly to the courthouse and to the clerk's office, where they were advised, we don't do this anymore, and their wills are not here. There is no will here. You might check with the Register of Deeds. Although the parties were obviously befuddled as they testified as a result of that, nothing happened until the daughter of Mr. O'Rourke, Mrs. Barney, commenced an intestate proceeding in September of 2015. My client, a stepdaughter of Mr. O'Rourke and a beneficiary under the will, was convinced that there had to be wills in the courthouse somewhere, so she contacted my co-counsel, Mr. Hanson, who, being a man of some maturity, remembered that there used to be wills deposited with the clerk. And a little sleuthing, he found the will in a closet in a lockbox in what used to be the probate court. Needless to say, I don't think the ledger's been maintained since nobody even knew where the wills were, apparently, or at least so they advise. He promptly commenced a proceeding to admit the will to probate. The probate judge did so. Mrs. Barney appealed, and after a de novo hearing, the district court also admitted the will.
Mr. Palmer,
Yes.
excuse me. Are you arguing that that's a knowing withholding, or do you have some, is this so unique that it should be treated differently? What's your...
Both.
Both, okay.
Thank you, Judge. First of all, this court's law is pretty well settled. In the case of N. Ray Strader, the court held that the statute 6 months limitation means what it says. It's a 6 month statute of limitation. If this case cannot be distinguished factually from Strader, I lose. It's that simple, I do believe. But I believe this case is clearly distinguishable in that in this case, in Strader and in all the other cases upon which were decided before, including the case overruled by Strader, the Harris case, the will was in the custody or lost by the scrivener or the attorneys, agents of the testator. People that the testator chose and were responsible to the testator and the beneficiaries, if to anyone, to produce the wills or to at least keep track of them. This case, I think, is different, where the clerk has a statutory obligation to produce the will when it's requested and timely. I do not think the fact that the clerk fails to do her duty or his duty is justification to deny a will for probate. We contend that the statute should be told equitably when the mistake is made by the court, not the testator or the beneficiaries or anyone else. The mistake that the trial court is trying to correct here is a mistake of its own court. And we believe that that is the fair and just result. In answer to your further question, Judge Malone, I feel that our argument is that if we have to fit this into a statutory category, the statutory exception to the 6 months limitation is a will knowingly withheld. And the argument is set forth in our briefs is pretty simple. Everyone is presumed to know the law. Certainly the clerk is presumed to know the obligations by statute and of this court's rules of her office. We contend that that knowledge that everyone is presumed to have of the law implies that she had actual knowledge or should have had actual knowledge, and that therefore the exception by the rules of logic in that should be applicable if we need to fit it in the statutory category.
Counsel, do you not have a cause of action against the clerk?
Possibly, if I could prove what the damage was, and if the statute hadn't already run, it's been more than 2 years.
Well, when the negligence of the clerk was discovered, you had 2 years on that point,
Yes,
correct?
it's possible that you would have it.
I'm sorry, it's possible what?
It's possible that, yes, that the beneficiary of the will, who is not a beneficiary of the intestate in the state, might have a cause of action.
How did the beneficiary under the will have knowledge that they were a beneficiary without having the will? And what led them to believe?
Well, the testator, the stepdaughter lived with the testator since she was 8 years old. And so she knew he had the will. And moreover, the record shows she testified that she talked to Mr. Sawyer, who was the scrivener of the will, out in front of the courthouse, who told both Mr. O'Rourke and her that the will was deposited with the court.
So he had a memory from 50 years ago about what took, more than 50 years ago about what took place around 50 years ago.
Well, I can still remember 50 years back. Just
No, I'm not.
Wasn't there a codicil unsigned found in the?
There was a copy of the codicil unsigned found in the bank box, I think, yeah.
And I guess I'm a little unclear. So you think you'd have a personal cause of action? I mean, a cause of action against the clerk personally when she was?
I don't know whether it's personal or I haven't read it.
And you think you could? You think under the Tort Claims Act you could sue the court?
Well, I still practice up there, so probably I'm not
Well,
interested in the case.
Well, the reason I'm asking that is that's a factual distinction that I saw immediately in my mind without researching the causes of action. It seemed to me that then Strader you had an attorney with potentially malpractice insurance, and so you would have a suable client. But when you have a clerk making a mistake on the job, it's real questionable to me whether you would have a viable cause of action against
Well,
it.
there is a case against a clerk in the city of Topeka cited in the briefs where the clerk, I think of the municipal court, was sued for a failure to perform some ministerial duty, but that was before the Tort Claims Act, so I'm not too sure.
And
Still
But
flies.
in order to have a cause of action, you lose because of Strader. Let's just
Yes.
assume that. And you had another route to go. You would have to show willful refusal, as I understand the statute, or willful neglect.
Knowing,
Well, it's
Oh,
knowing
I mean,
withholding the will.
yeah.
That's the one issue that
Yes.
would save you there. But the liability goes to a willful neglect or a willful refusing. Is that if you can't show knowing withholding, can you show willful neglect?
Well, I suppose all we could really show is that the clerk had this duty by statute and court rule and failed to perform a ministerial duty.
And that's your distinction with Strader. I mean, you
Yeah.
have to distinguish Strader. Is there anything else that distinguishes other than the court not fulfilling its duty?
The fact
Is
that
that
the
what-
will was with the court is the distinguishing
Okay.
factor.
And there is a statutory requirement for the clerk to maintain a list.
Yes. Well,
And more than just maintain a list. They
actually
have
a
some
court rule.
custodial duties with respect to this will.
sorry?
That's the clerk had some custodial duties with respect to this will that a privately retained attorney would not have the statutory duties.
That's
It would
correct.
be simply a matter of contract, and as you said, as they would be acting as an agent for the testing.
yeah. That's the distinguishing factor.
What do we make of the fact that the statute describing knowing withholding talks about withholding from the district court? And so even if it's knowing, the district court had it.
Yes. Well, there is that fact. Yes. you are.
So it
I
wasn't
don't know what the
withheld
effect
from
of
the
that
district
is.
court,
I'm sorry?
period. It wasn't withheld from the district court at all.
It was withheld from the executor.
Right, but
Yeah,
the
it wasn't
statute
withheld
talks
from the
about
court.
withheld from the district court.
Well, no, it wasn't withheld from the court. It was found in the court.
That's such a strange circumstance, I guess.
Well, my co-counsel and I disagree as to whether these facts are likely to come up again, but I suppose as clerks get younger, there may be fewer of them that know
what
they have this.
it makes me wonder is, even given the unique facts here, could it be said that the probate was actually filed? I mean, it wasn't filed, but effectively was filed with the district court within 6 months?
Well, I don't think so, Your Honor, because this is just a preservation thing. It's always been incumbent on somebody under the statute to take the will and to get it admitted. Just because it's filed doesn't mean it's
Right. So
it's admissible.
back in the days when the clerk read the obituaries, as you said, the executor or some beneficiary would come and say, "Hey, you have the will. Let me file
Yes,
the
and they give it.
pleading." But that was attempted here, right?
Yes, yeah. I mean, the two co-executors named in the will along with one of the beneficiaries, went to the clerk's office.
Could they have filed a petition for probate without the will?
Well, they didn't have a copy of it.
I know, but could they? Is that, or would they have been prevented from doing that?
Well, I
In
know
other
you
words, are you required to have the will when you file the petition to probate?
Well, you can often get a copy of it
Well,
admitted, but we didn't even have the copy.
I'm just asking, legally speaking, could your clients have filed something called a petition to probate without having a copy at all?
I think it would have been most difficult because I don't think anybody really knew what the will provided exactly.
And you have to, you just don't admit a piece of paper. To admit it, you have to authenticate it. You have to have witnesses, know who the witnesses are, and either have a self-executed will, or you have to have the testimony of the witnesses that they saw. And all of that. There's a lot of hoops to jump through between pulling out the lockbox and getting the will and having it admitted to probate.
Certainly. Well, the Court of Appeals decided that my suggested distinctions from Strader were superficial. We think not. We argued to the court that the Court of Appeals should be reversed, and the district court affirmed, and the court allowed to correct the mistake that it created through its officers, and that the overriding principle of Kansas law that people not die intestate, that is the just result in this case, justifiable under the law. It is a somewhat unique circumstance. We believe that the exceptions that we have suggested well justify it, and the end result is a just result. Is there no more questions, Austin?
Do we have any more questions? Thank
Thank
you,
you.
counsel.
May it please the court, my name is Michael Jelka. I represent Karen Barney, the daughter of Ray O'Rourke and the appellee in this appeal. We are asking this court to uphold the Court of Appeals ruling denying admission of this will to probate.
Counselor, you were the original appellant, right?
That's correct.
Okay, all right.
Since I was sitting at the appellee's table, I guess I thought I should say appellee. We were the appellant technically. We brought the appeal. We prevailed at the Court of Appeals. So in the In re Estate of Strader case 4 years ago, this court held that a will that has not been knowingly withheld from probate, including a will that simply has been lost or misplaced, is not admissible under 59-618 after the 6-month limit of 59-617 has expired.
Was this will lost or misplaced?
I would call it misplaced. Your
It wasn't
Honor.
really.
It's a kind
It
of
was exactly where it was supposed to be.
Well, it was deposited in the court pursuant to the then existing statute, and the court was unable to locate it upon request. So it was lost at the premises, but I think whether it's lost or misplaced, the rule of Strader applies to both situations. Now, this court has specifically cautioned or disapproved of any interpretation of 59-618 that softens the knowingly withheld requirement of the statute. And further, this court's precedents established that when the legislature fails to modify a statute in the face of a standing judicial construction of the statute, then there's a presumption that the legislature intended the statute to be interpreted as the court has previously done.
Well, it talks about person, the statute, and this is, as Justice Stigall indicated, a clerk acting in a ministerial role. It was where it was supposed to be.
Yes.
So you see no distinction there.
Yes, we see no distinction between a private actor, for example, an attorney on the one hand, and a government actor on the other hand. We think the statute applies across the board, regardless of the identity of the actor.
What if the district court clerk had just said, yeah, we have it, but I'm really busy. I'll get it to you sometime. and it takes them 10 days or however long. Maybe it takes them months. Is the will still prohibited
Well,
from being probated?
That fact would be a deliberate sabotage by the governmental actor here.
But the way you've argued the case, it seems that you don't think that matters.
We take a categorical approach to the statute.
Right.
I mean, I'm not quite sure I can. The hypothetical that you're posing of deliberate sabotage is not presented to the court, but we take a strict construction of this statute, which we think is faithful to the precedent that this court applied in Strader.
Well, if you concede that some kind of deliberate act by the court could toll this period of limitation, then we would be confronted with trying to decide how far along that spectrum these facts actually are.
Well, I'm not asking the court to go that far to.
You're saying it can't be told no matter what, even if it is deliberate.
That is why I'm saying you should leave that deliberate sabotage issue maybe for a future case that actually presents those facts. But I do concede that I am presenting a categorical argument that there is a requirement in the statute, per your holding in Strader, that someone knowingly withhold the will. And the court in this case has specifically found that the withholding was inadvertent. And in that respect, I disagree with my adversary's statement in his argument where he says that there was knowing withholding. In response to your question, Judge Malone, there was a specific finding here by Judge Nafziger that the withholding was inadvertent. So,
was there a withholding at all? The statute says withholding from the district court.
Well, there was a request by my client, Mr. Palmer's client, and the two grandchildren who went to the court and asked. So yes, I think there was a withholding, but
not under the language of the statute, though, right? The statute only talks about withholding from the district court.
Well, it's sort of
it just seems to me that exception doesn't even contemplate this scenario.
It is a unique factual circumstance. I do concede that. A will deposited with the court back in 1954. But there was a withholding here because there was a request, but the court has specifically found it was, the district court that is, it was inadvertent, i.e. not knowingly. So that's why we believe the statute is not satisfied here.
Mr. Joke, I know you know the slings and arrows of the changes of the clerks of the district courts throughout the state and in other counties near here. And of course, a lot of knowledge that they're supposed to have isn't passed on to the next hire, the next whomever. Was there a constructive knowledge here, given the fact that the law indicated that the clerk had this ministerial duty to preserve the record?
Well, there admittedly is a court rule that
a statute.
A statute that said that the wills would be deposited. The statute 59-620.
I'm sorry, that was a rule.
But there's a court rule that I would concede presents a duty on the clerks to keep those wills, keep a list of those wills deposited under that statute. But I'm not. The idea of constructive knowledge, that concept bothers me. I think that knowingly is actual knowledge. And I think that's what the statute 618 addresses, not constructive. And that would involve sort of judicial determinations of when should they and shouldn't they have. And I don't think the court wants to go down that road. It instead should rely upon the factual determination of the district court whether this will was knowingly withheld. And here there's a specific factual finding that it was not.
Well, but a properly trained clerk would know that indeed they did have the will, and they told they made an effort. They went and said, we don't do that anymore.
In a perfect world, that would be true, Your Honor. But I would also say I would analogize to the situation of the facts of Strader or the facts of In re Estate of Tracy, where after all a will was discovered 6 months and 3 days after the testator's death. That arguably works an unfairness, but it's still the law under Strader that holding has been disapproved. And the same thing in Strader, where the Galloway firm, arguably that law firm should have a duty to be able to access wills that they have drafted upon request of the testator's family, and were unable to do so, yet that did not change the outcome there. So I think that the same rule has to apply across the board. Knowingly withholding applies not just to private actors like attorneys in Strader and Tracy, but also to government actors in this scenario.
Well, we're talking about the district court, which the statute mentions. We're not talking about a government actor. We're talking about the district court, withheld from the district court. It seems to me that's the distinction between your private actors who withheld in their law office, not in the district court, if you're looking at the plain language of the statute.
Well, but the statute still requires this to be knowingly, and the district court has found that it's inadvertent. So I contend that the statute has not been satisfied.
But if factually, if it was a factual inadvertence, but we decide legally that the clerks were presumed to know the law, and that imputed knowledge of the list means that it's a knowing withholding. Even though it was actually inadvertent, it can be legally knowing if they are, if we impute that knowledge to them, that constructive knowledge to them.
Well, at that point, you would be just in contrast to the district court's factual finding, you are just legally saying that knowledge always occurs in circumstances where wills are deposited with the district court under 59-620.
It'd be a legal fiction, basically. It'd be a new legal
I think
fiction.
that argument
wouldn't be totally in left field. I think the Wilshire Oil Company of Texas case back in 1965, I think it was 10th Circuit case, said clerks of the district court are presumed to perform their duties. And so we've got some cases that presume that clerks know what their duty is if we're going to presume that they do their duty. So it's not out in left field if we are presuming the clerk here knew her duty.
Well, I would also say this, Justice Johnson, in the Strader opinion, this court actually made reference to KSA 59-620. You were discussing your disagreement with the Tracy analysis, and you referenced the court's reference in that case to In re Estate Harper, and mentioned the statute including 59-620, and you were making the point that this legislative policy of presenting all legally executed wills to probate was qualified by the limitations period of 59-617. So it seems to me that the logical, where the argument that you're presenting, Justice Johnson, runs afoul or is discordant with that specific reference to 59-620 in the Strader opinion.
Counsel, your opponent would like us to go to equity. Do you have an equitable argument on behalf of your client?
I would say this, Your Honor. I mean, they have articulated this unique circumstances doctrine in their brief, and that's kind of the linchpin of their equitable argument. And I know this court has discussed the unique circumstances doctrine in the Board of County Commissioners versus City of Park City case back in 2011, and that case dealt with jurisdictional limits, and the court overruled the doctrine in those circumstances. Now, conceitedly, this case involves a non-jurisdictional setting, the statute of limitations, but I would say this. First of all, there is a specific savings statute in the probate code found at 59-618, and in our view, adopting a unique circumstances doctrine and applying it to these cases would, in our view, eliminate the knowingly withheld requirement and effectively overrule Strader. And it would run afoul or run in contrast to the principle that I've articulated that when there's a standing judicial construction of the statute, that there's a presumption that that statute or that interpretation should hold.
The idea that is what this court does and Strader applies to this case, do you think there's a civil liability on the clerk's part?
It's very possible, Your Honor. I mean, after all, with the advent of the Tort Claims Act, governmental actors are supposed
Well,
to be...
assuming they're not immune because it's not a judicial
Sure.
function but a ministerial function, which would be then subject them to liability. That statute talks about a willful neglect or willful refusal. Contrast that with knowingly withholding. I mean, aren't they all in the same thing? So is there really a civil liability?
Well, there are...
Is Mr. Palmer's just out of luck?
There's, I hope to say he's out of luck here, but I would say that those terms, they are certainly overlapping. I can't really distinguish what's knowingly withheld versus the term you're presenting here, willful. I would think they are substantially overlapping here. Now, whether there's a liability, it just may be the case that a governmental entity, after all, in this case, where they acted in good faith, where they actually made an attempt to find it, and after all, this will was deposited back in July of 1954, that there could be an argument that maybe that's not negligent for a clerk's employee not to be able to find that. I know they're under a duty to do that, and they on the facts of this case, they certainly tried, and they even directed the family down to other parts of the courthouse. So a vigorous attempt was mounted to find this will. So factually, I have some difficulty with seeing how tort liability could accrue against the clerk for what she did in this case. I don't rule out the possibility that there might be some cause of action under the Tort Claims Act. I think that's an issue of perhaps to be left for another day when the issue arises.
Counsel, I have one more question at least.
Yes.
How do you respond to the proposition that perhaps this will was actually constructively filed for probate with the district court within the 6 months?
When you file a petition to probate a will, I would think the will would need to be included because we need to know that...
And I understand that.
Okay.
And that's why I said constructively filed. Obviously, there wasn't a petition filed, but the district court had the two. It seems to me possibly the district court had the two key things it needed to have the will filed for probate. One, it had the will, and two, it had the beneficiaries of the will come to the courthouse and say, "We want to file this will for probate." So if we take those two things, arguably at least, I could see the argument that suffices to satisfy the 6-month limitation period. Within the 6 months, those two things happened within the 6 months.
So the hypothetical is if a petition had actually been filed without the will within the 6-month period.
I'm just saying, not a hypothetical, just our facts. These people came to the courthouse and they said, I'm not reading from the record, but words to the effect that I want to probate this will, and you have it. Why can't that be treated as a constructive filing of the will for probate within the 6 months?
In this case, the petition was not actually filed until 11 months after.
I understand that the actual petition was.
You're saying just a written request. If they had actually hypothetically actually filed without the will, I think the statute requires that the original will be submitted with the petition to institute a probate
You're
case.
still talking past each other. I think, Justice Stegall, if I may.
Go ahead.
I think what he's trying to say is just assume the facts exactly as they are. The will exists. It's in the courthouse,
Yes.
in the clerk's office, and the beneficiaries come to the courthouse and say, "We want to petition for probate of this will. That's our intention, and you have the will." So that's what happened here in essence. It may not have been exactly those words, but that's what happened in essence. Would you agree with me that those are the facts of this case?
Yes, I think so.
Okay.
Yeah.
So we'll assume that I think my colleague is just saying, assuming those facts, why is that not a constructive filing, a constructive petition for probate with the will?
Well,
Because the will's already there.
The petition was not
Right.
actually filed within the 6 months of the testator's death, is the distinction I draw here. It was not filed until 11
But they
months.
showed up well before the 6 months expired, right? They showed up and asked for the will.
Yeah, the week
before.
after the testator's death, or 2 weeks after the testator's
So
death.
is it just impossible to have
Well-
on these facts a constructive petition for probate?
Right, what you're getting at is just an oral request, a petition? And I would say, no, you have to actually file a document with the
Okay.
district court.
So you would say it still falls short on
Yes.
a written oral
Yes, I do.
petition? Okay,
Okay.
thank you.
Do you have any further presentation?
Nothing else. Thank you for your time.
Any more questions? Thank you, counsel.
If your honors, please, I'd just like to correct a little bit of the record, factually, what occurred here. This will was not lost or misplaced. It was in the clerk's office. The clerk just didn't know that that was her duty. The trial court found that she was just mistaken. But mistaken is a nice way of saying she didn't know what she was supposed to do. She didn't know she had the wills there. So I continue to believe that that is a completely distinguishing factor factually from Strader. I mean, the appellee here has one horse and he's ridden him about as far as he's going to go in trying to fit this case into Strader, but factually this case is not Strader because of the unique circumstances that we've discussed of the will already being there and a clerk, the court official, failing to know or to do her duty and give it to the co-executors who asked for it timely. And we think that equity certainly requires that the statute 6
Once a
months be
timely
told.
request was made, does this just for time in memoriam reserve the right? What if the will was found not 11 months later, but 2 years later, 5
I
years?
think if no one made it, I would have
But
a
the
tough
request is
time.
made, but isn't found. I mean, what happens 5 years down the road?
Well,
We do have it.
I think if you don't even make the inquiry within the time to file the will, I would have a hard
No,
time.
let's say
making-
the inquiry's made.
The inquiry's made, but nobody does anything?
Yeah, nobody does anything, or no, we don't have it, and then but like here, it was discovered later, within a year. What if it's 5 years later, the will is discovered?
I think,
Same equity kind of relief?
well, possibly, but not likely, because there would be many intervening equities. The estate would have already been probated, assets distributed. So I would think I would have a very tough time making that argument on an equitable basis.
Well, the exception, the statutory exception, anticipates the intervening interest because it accepts any purchasers for
Real estate. But
in good faith and that sort of thing. So it anticipates that there will be other equities intervening, doesn't?
well, that's true, yes.
Do you have any further presentation?
I do not, Your Honor. Thank you.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement.